Well, selling your business is way in the future. When you incorporate and start to scale your business, it is important to keep in mind that end goal. It's very, very important that you keep very diligent records of everything. So your minute book has to be kept up to date. Everyone's got to be party to the shareholders agreement. You've got to have all the shares issued. You've got to have ordinary meetings once a year of shareholders. It's also really important these days to keep a virtual data room, whether in a Dropbox or in a private cloud system, where you have all of your NDAs kept. You have all of your intellectual property agreements of all your employees, consultants, and developers kept. You have all your significant contracts. And you need all that because when and if a merger or acquisition comes along, the buyer, prospective buyer, is going to ask to do a lot of due diligence. And in doing that due diligence, they're going to be asking to see all of your books and records. And that means all of your contracts, all of your financial information, all of your tax information. And it's always good to basically have a virtual data room going from the very outset. And that's something we do a lot with our clients. Let's assume you've been doing business for a while, and maybe the odd strategic partner has come along. Maybe you're doing channel sales through them, or you have had a significant development project with a party, or a third party just happens to reach out to you at a trade show and becomes very interested in your technology. And maybe it begins to lead to something called an M&A, or merger and acquisition. These take many forms. The discussions go on for quite a long time. Sometimes these things can happen very quickly. Sometimes they can take years. Often, if you have a high price in mind, they often take a few kicks at the can, and we've had many, many very successful entrepreneurs sell to a buyer, not the first time they came knocking on the door, but the second or third time, because the buyer just wasn't willing to pay the price the first and second time that it was asked. But as the company grew and as it became more successful, that buyer kept an eye on the company and said, I gotta buy it. Now, what kind of form can the sale of business take? Most of the time, businesses are sold through the sale of shares versus the sale of assets. Basically, a sale of your business by way of shares means that all of the shareholders are selling their shares 100% to a buyer. Now, what happens to option holders or warrant holders who hold the right to buy shares? Well, we have to deal with those as well. And so typically an option plan will allow the board to accelerate options that haven't vested. Warrant agreements will say that they have to be exercised or be lost on a sale of the control of the business, which typically is where you sell up to 100%. It could be something less, it could be control as in over 50%, but most buyers really want 100% of the business. So typically share sale is the way to go, and share sale, as you've heard about from other of my colleagues, is a great way for founders to go, especially if you own shares of a Canadian-controlled private corporation, a CCPC, and you've owned those shares for 2 years. Under current legislation, if you've had shares in a CCPC and you are Canadian-controlled at the time of the M&A, the first $800,000 of gain on those shares can be tax-free, capital gains tax exemption, provided you haven't used your lifetime exemption before. And that's why it's very important when you structure the company to try to ensure that Canadians control the company, which means over 50%, and that those Canadians are not public companies, so that they're VCs, which are typically fined for purposes of calculating Canadian control, or other kinds of investors that are not represented by public Canadian companies. So assuming you have a CCPC, a share sale is a great way to go.